I see all our panelists are here, so we are going to reconvene. It's my pleasure to introduce the moderator for our last panel of the day. We've been talking a lot about the PTAB, and now we finally will have a panel that will address the PTAB issues directly. The moderator for this panel is my colleague and co-director, David O. Taylor. He is a professor of law at SMU, Dedman School of Law. Before coming to the law school, he spent several years as a patent litigator for Baker Botts here in Dallas. He has a mechanical engineering degree from Texas A&M University, his JD from Harvard Law School, and after graduating from law school, Professor Taylor clerked for the current Chief Judge of the U.S. Court of Appeals for this Federal Circuit, the Honorable Sharon Prost. And so with that introduction, Professor Taylor, I will turn it over to you.
All right, thank you for that great introduction, Professor Robinson, and good afternoon, everybody. My name is David Taylor, and I'm happy to be here. I will give credit to Professor Robinson, though I just want to highlight he has been the ringleader of the event today, and he's done a great job. So I'm very happy to moderate this session. It's entitled Perspectives on the Patent Trial and Appeal Board. Let me first briefly describe what we hope to cover in this hour. As we all know, in 2011, the American Invents Act created the PTAB, as well as several new proceedings to reevaluate the patentability of issued patents before the board. In this panel discussion, we want to reconsider the reasons for the PTAB's creation, evaluate the history of the PTAB's activities, analyze recent litigation involving statutory and constitutional challenges to the PTAB and its judges and its practices, and evaluate related recent and proposed regulatory and legislative reform. So we have a full agenda. We'll see if we can get to all of that. And now let me introduce our panelists. So in alphabetical order, first we have Arti Rai, who is the Elvin R. Latty Professor of Law and Faculty Director of the Center for Innovation Policy at Duke Law School. She graduated from Harvard College with a degree in biochemistry and history, attended Harvard Medical School, interestingly, for 1 year, and then went over to the Harvard Law School where she received her JD. Prior to entering academia, she clerked for a judge in the Northern District of California, and was a litigator at Jenner & Block. She also worked in the Department of Justice. Notably, for our purposes, from 2009 to 2010, Professor Rai also headed the Office of Policy and International Affairs at the USPTO. In that capacity, she led policy analysis of patent reform legislation that ultimately became the American Invents Act. Next, we have Amy Semet, who is an associate professor of law at the University of Buffalo School of Law. She graduated from Dartmouth College, where she studied government and history. Then she attended Harvard Law School as well. And she also, though, obtained a doctorate in political science from Columbia. After obtaining her doctorate, she worked as a postdoctoral fellow for 3 years at Princeton University. She also served as a visiting fellow at Yale Law School's Information Society Project. She clerked at the Federal Circuit for Judge Paul Michel, and she was an associate for 6 years at Simpson, Thatcher, and Bartlett. In her academic life, her research has focused on studying legal institutions and intellectual property, including the PTAB, from an empirical and statistical perspective. Our third panelist is Saurabh Vishnupakat, who is a professor of law at Texas A&M University School of Law, but he's also a professor of engineering at Texas A&M University, and he's a research fellow at Duke Law Center for the Center for Innovation Policy. He has a Bachelor of Science in Chemistry from Georgia Tech. He has a JD and an LLM in intellectual property law from the University of New Hampshire School of Law. He served as a postdoctoral associate at the Duke Center for Public Genomics, so several ties to Duke, and that is where Arti Rai is. So he served, interestingly, in the U.S. Patent and Trademark Office as a principal legal advisor to the USPTO's first 2 chief economists. And his research focuses, of course, on intellectual property, but as well, there's a common theme here: administrative law and federal litigation, especially from an empirical perspective. So with that, let me hand you off to Professor Rai for her opening remarks.
Thanks so much to the folks at SMU for inviting me, and particular thanks to David Taylor for moderating this panel, and to the audience for staying with us for the last panel of the day. So what I'm going to do is give a very quick tour of why the PTAB was created, and to some extent how intentions have matched up with reality. Of course, that last part is an ever-evolving tale, so I can only say a little bit about that. So with respect to history and why the PTAB was created, in the early aughts, the prevailing sense was that poor quality patents were causing significant economic problems. So in 2003, both the Federal Trade Commission and the National Academy of Sciences wrote very influential reports detailing what they perceived to be the problems caused by so-called poor quality patents. The narrative at the time related primarily to software and business method patents, including software-enabled business method patents. It was not, however, necessarily a narrative about patent trolls. It was a narrative just about poor quality more generally. And the poster child was an example of a poster child, at least, was Amazon's patent on one-click ordering over the internet. Now, two trends, one legal and one technological, had coincided to create these sorts of patents. The first was legal. That was the expansion by the Federal Circuit through the 1990s of the scope of patentable subject matter, under Section 101. And the second was technological. By the late 1990s, the internet had begun to intrude into every corner of economic life. So in thinking about the challenge posed by what they perceived as poor quality patents, the FTC and the national academies were influenced by the idea that spending lots of time ex ante evaluating the hundreds of thousands of applications that the Patent and Trademark Office gets each year would not necessarily be cost effective. The claim that they agreed with was that most of these patents, at least many of these patents, even those that, certainly applications that became patents, many of those patents would not necessarily end up being important economically. So instead, the FTC and the national academies looked to Europe, and in so doing, they were influenced by various economists and legal scholars. So this was a situation, I think it's fair to say, where academia did have some substantial influence on what the FTC and the national academies did. At the time, various scholars, principally Bronwyn Hall and Stuart Graham, who would then subsequently become the first chief economist of the USPTO, had become increasingly convinced that the administrative opposition procedures at the EPO were doing a reasonably good job in accurately and cost-effectively weeding out poor quality patents. Both the FTC and the national academies strongly recommended in their final report some sort of robust post-grant opposition procedure. And that idea, interestingly, was also extremely well received by the APLA, the IPO, and the IP section of the ABA. So everyone was singing the same tune to some extent, at least at a high level of generality. Congress then held hearings, and that's where some of the devilish details got messy, not surprisingly. In part, this was because Congress had to figure out how the proposals for transplanting what had been conceived of as a European procedure for more robust post-grant proceedings would interact with the post-grant reexamination hearings that were already in place. And these were ex parte reexamination, which still exists, and inter partes reexamination, which ultimately ended up being abolished by the AIA. But even more fundamentally, I think there was some tension between how key players in the debate viewed the purpose of a more robust post-grant proceeding. Everyone agreed that the proceeding should be about cost-effective and accurate error correction, and agreed that, in principle at least, an administrative agency that granted patents would be more likely to have the expertise to do that accurate and cost-effective review post-grant relative to district courts. But some analysts viewed these procedures perhaps as being only an explicit substitute for district court litigation. Others envision the procedures perhaps more capaciously as not simply a substitute for district court litigation, but also a type of extended reexamination, more robust reexamination that could occur even absent any district court litigation. So that was one tension that was there at the beginning, which continues to play out in various ways to this day. Additionally, there was a tension, which also continues to play out to this day, surrounding the possibility that these proceedings would create harassment, particularly of small, under-resourced firms. Harassment is obviously a possibility anytime the costs of litigation are lowered, because that means that there can be more ability to attack the patent right in this case. So ultimately, as with all grand compromises, the AIA was a grand compromise. And what we got was a bit of a hybrid that didn't encapsulate any single stakeholder's vision, but tried to compromise between the visions of multiple stakeholders. And so there are contradictions and tensions in the statute, and I think we should be candid about that. So the preponderance of evidence standard of review, the lack of standing requirement for administrative review, and the ability, at least in principle, to amend one's claims make the proceedings look more like an administrative redo rather than simply a substitute for litigation. And post-grant reviews, which are available only for 9 months after the patent is granted, clearly tend towards more of the administrative redo model, because in that case, all grounds for patentability or patent validity can be brought forward. In contrast, inter partes review, which is the lion's share of what we see these days at the PTAB, is available throughout the life of the patent and takes something more of a substitution model, I think it's fair to say. So a defendant in an Article 3 suit can only bring a petition for inter partes review within 1 year of being sued, at least in principle. There's also a relatively strong estoppel provision that prevents arguments that are made in the administrative context from being remade in the Article 3 litigation context. So I think that it's fair to say that it's a hybrid and there are tensions as a consequence of the hybrid. One question that also came up at the time of the AIA that I think is important to bring to the fore is that the general view was that we were moving towards a more administrative approach to error correction. That was all agreed upon. But there was a sense that if we were going to do administrative approaches, why not go all the way and give the Patent and Trademark Office the full scope of rulemaking authority that many other agencies have. And that ended up being a particularly important point because the AIA debates were happening against the backdrop of litigation against the Patent and Trademark Office about rules or proposed rules that had set forward on continuations that allegedly exceeded the scope of its rulemaking power because they were allegedly substantive and not procedural. So there was a question of whether one could moot that whole debate by just giving the PTO more plenary rulemaking authority. And rulemaking authority from an administrative law standpoint is essentially the crown jewel of the administrative state. And so that was actually in some of the early versions of predecessors to the America Invents Act. That proposal for full rulemaking authority ultimately got removed because it was considered quite radical by many in the patent community. Nonetheless, and this is a point that I think has continued to linger, because these inter partes review and post-grant review procedures look pretty formal in the scheme of the way that the Supreme Court has set up what constitutes formal versus informal adjudication, some, myself included, argued that there was some argument to be made that these were formal enough procedures, the PTAB procedures, that there might be some deference due not simply to the fact-finding done in these proceedings, which there's fact-finding in general to PTO proceeding, deference to PTO fact-finding in general, but also to legal determinations and maybe even policy determinations made during those proceedings. And there was a provision, the AIA section 324B, 35 USC, that talks about how the PTAB in the context of PGR can hear issues that are raised or can hear cases that raise new policy issues. So 324B seemed to suggest to some of us, at least, that there was a policymaking component to the PTAB. So that's intention. Now, what about results? I won't spend too much time on the empirics because Professor Semet and Professor Vishnubhakat no doubt will have lots of empirics, and including some stuff that I have done with Professor Vishnubhakat. But I will talk just a little bit about what I see as the general trend with respect to empirics, and then also about results with respect to the Supreme Court and its extreme interest in the PTAB and what that's all about. So overall, as an empirical matter, I would say that the PTAB has experienced growing pains over the years, certainly, perhaps even some would say substantial growing pains, but I think that it's fair to say that the PTAB judges themselves are regarded as doing a fairly good job of evaluating the science, at least at the post-institution stage. I think they're considered pretty good at that task, particularly relative to district court judges and perhaps particularly juries. I would say that the big controversy set of controversies surrounding PTAB has to do with it's getting caught up in larger fights in patent law, and then also in administrative law, and perhaps above all in fights about the scope of administrative power versus Article 3 judicial power. So the larger fight in administrative law that many of you probably are well aware of is that there are many folks who think that the pendulum in patent law has swung too far in an anti-patent direction. So in addition to the AIA, a few years after the AIA, although we didn't get explicit additional legislation that was, for example, targeted at patent trolls, we did get the Supreme Court moving very aggressively in Section 101, and perhaps as its own way of dealing with what it saw as a troll problem. So that's the patent entanglement, the substantive patent law entanglement that I think the PTAB, has gotten itself wrapped into. And then more importantly, from the standpoint of the Supreme Court, there's a big, I would say, fiery debate in administrative law over whether administrative adjudication is necessarily a good idea. So I think that it's fair to say that that was not necessarily a debate that existed 10 to 15 years ago, because administrative adjudication seemed more well-placed in the administrative state at that point. But with the ascension of Justice Gorsuch, in particular, the Supreme Court, I think administrative adjudication and its role in the administrative state has taken on a more controversial, has a more controversial aspect to it, particularly if one considers property rights and patent rights as property rights. The cast that is, or the pall that is cast upon administrative adjudication perhaps becomes greater. And that's really obvious in the two constitutional cases that the Supreme Court has taken, Oil States and Arthur X, which will be argued on March 1st. But it's also clear, I think, in sub-constitutional cases involving the scope of judicial review, so Quozo and Sass and Thrive, where you've got a combination of interesting combinations, I should say, of justices saying that should be a huge presumption of judicial review. So Gorsuch and Sotomayor joining up in that regard, and the dissent, I think, by Justice Gorsuch in the Thrive versus Click to Call case is particularly worthy of attention, where he talks at great length about what a rough day that the decision by the majority in that case has occasioned for judicial power, and how much he laments how judicial power is being taken away, and he means Article 3 judicial power, by the Supreme Court. And so I'll conclude by reading one paragraph. It's a rough day when a decision manages to defy the plain language of a statute, our interpretive presumptions, and our precedent. But today, that's not the worst of it. The court's expansive reading of 314D takes us further down the road of handing over judicial powers involving the disposition of individual rights to executive agency officials. So that's the kind of stakes that at least some Supreme Court justices see with the PTAB. And we will perhaps see some of that on display on March 1st. So thank you.
Thank you, Professor Rai. And now Professor Semet.
Yes, thank you, Professor Taylor, for inviting me, and the Tsai Center for having this symposium today. So I'm going to present, I know if I can share my screen now, I'm going to present some of my research with respect to the PTAB and my empirical analysis I've been undertaking of the PTAB over the past few years. So as many people in the audience know, this particular analysis concerns the IPR provisions of the PTAB, which is the majority of the decision-making that goes on at the PTAB today under the American Events Act. There's other procedures that also are used, but the majority of them are IPR proceedings. And this followed on from prior to the American Events Act. There was the inter-party and ex-party reexaminations. And this was meant to be a cheaper and quicker way to resolve some cases ahead of the district court litigation. So importantly, with the IPR litigation, it's only based on anticipation, obviousness, documentary prior art. So other types of challenges to patent validity based on other Section 101 grounds, Section 112 grounds, or public use or on sale bar, anticipation or obviousness determinations would not be permitted under the IPR proceedings of the PTAB. So brief, for people who don't know how the PTAB works, just about, it's a very streamlined process where there's very strict deadlines about how things happen. And it's heard in 3-judge panels where the court first decides, the 3-judge panel first decides whether to institute the proceeding. And at that stage, they can deny institution, or at this time, people might settle as well. If the court decides to proceed, the panel would then go through discovery process with deadlines for different things respecting discovery. And then there will be an oral hearing, and ultimately a 3-judge panel will issue a final decision. This entire process is designed to take 18 months. So you can see where this is an advantage over district court litigation, which may be uncertain with respect to timing, because the deadlines provide a very streamlined way of moving the case along with respect to determining validity of the patent. So with my empirical analysis, I've analyzed both who are the PTAB judges, as well as how is the administrative agency actually making these decisions. So with respect to the PTAB judges, I've obtained from the PTO, from a Freedom of Information Act, the CVs of most of the PTAB judges, and was able to look online at LinkedIn and law firm websites to collect more information about the judges. So I think there's probably interest about who these judges are, because unlike other administrative agencies, these judges, patent law judges, they're not the same as administrative law judges, or so they kind of have a unique role in the administrative law landscape with respect to being administrative adjudicators. So I collected information about their gender, their law firm experience, where they served as a patent examiner, their prior scientific expertise, as well as what law school they came from. And I'm going to gather information about the race and ethnicity, as well as other work they've done with respect to patents or published articles. And when I found that of the PTAB judges that I've able to get information from, about 38% are female, 23% had priorly served as examiners, 13% priorly served in the PTAB lawyer's office, solicitor general's office, solicitor's office at the PTAB, 20% former federal circuit clerks. Most of them have been in private practice. About 40 45% have been engineers and general counsel, median age of 48, and most had not gone to T14 law schools, but a lot of them had gone to law school in the DC area, which is not surprising. And then I kind of looked at what their fields of study were, and the PTAB, when they organize cases, they go under 12 different fields of coding, how they code the technology of the case. So of the bachelor's or master's degree, the highest degree of the PTAB judges, the plurality would have been electrical engineering, and then secondarily biology degrees. But you have judges in all different chemical, biological, and engineering type fields. And then I characterized the judges according to their career path and really saw a couple of different patterns. Namely, there's 40% judges that were at the PTAB for the culmination of the career after a lustrous career in patent law, and then a core group of judges that were fairly new to the patent bar, that then maybe had been an associate at a law firm for a few years and then decided to, then applied for a job at the PTAB. In addition, some of the judges were formerly worked at the PTO or were scientists in themselves or worked at the DOJ. In addition to collecting information about the judges, I've also collected information about the PTAB decisions and wanted to see how they compared with the district court decision making. So the PTAB has, from the last 8 years of decision making, has about 12,500 cases, and you can get information about the patent, the technology class, whether it was instituted, the claims, the prior art, and the judges on the panel, as well as the statutory section challenge, whether it's a 102 action or a 103 action. So as others have found, 80% of PTAB cases are also filed in the district court. So for the most part, there is a companion district court litigation for most of the PTAB cases. And of all the patent litigation in all district courts since 2000, 20% of patent litigation in general involves some type of PTAB patent. So if filed in district court, most cases are stayed, but significantly, a lot of cases aren't, particularly cases that are coming from the Eastern District of Texas or District of Delaware, which are far likely to grant stays. There was an 84% match between petitioners at the PTAB and the parties before the district court. So you often will see the same parties litigating, but significantly you see a fair share of parties that are unique to the PTAB. 7,800 unique patents in total, about 900 patents that were litigated exclusively at the PTAB. I found that a lot of the ones that were litigated exclusively at the PTAB disproportionately concerned biotechnology inventions, which I found was an interesting finding. So a lot of the biotechnology companies will litigate exclusively at the PTAB, and then perhaps only then when there's a resolve, then they'll proceed to a district court proceeding if it's not resolved in their favor. And then of unique proceedings, parties can file multiple proceedings involving the same patent, involving different claims. In addition, there are multiple proceedings involving the same patent. So for instance, the same patent, a party may file a petition against, multiple different parties can file a petition against the same patent. And the same party can also file the PTAB petition against the same patent owner for different claims of the patent. So among the technology classes of all the petitions, I found that for the most part, they're fairly split among the different technology classes, with it being dominated by communications and semiconductor and electrical engineering, being the largest group of PTAB petitions, and secondarily computer networks and computer architecture. In addition to looking at who the parties are, I looked at who the patentees in the PTAB litigation are. There was a perception that with some of the patent assertion entities or patent trolls, would they be disproportionately affected at the PTAB? Most of the patentees are corporations, a majority, but you have a fairly significant amount of patentees who are the patent assertion entities, and a very small amount who are small companies or individuals. So my overview of PTAB outcomes, this consists of the 12,500 outcomes from 2012 through December 2020. And you see that there's a lot of cases settle. You have a variety of cases that will go on to be instituted, meaning they'll go on to be heard, and then a fair share of cases in which the panel finds the patent invalid. So for substantive decisions, namely whether it's denied or whether the panel will then go on to rule on the merits of the, about 40% of the PTAB petitions are at the institution stage are denied in this case for substantive decisions. And when they reach a substantive decision, for the most part, they disproportionately will hold the patent invalid in whole or in part. About 40% of the time, it's unpatentable for all the claims asserted in the particular petition. And then for about 20%, it's a mixed finding where they find certain claims would be supported and some not supported. Then at the merit stage, where you just get at the stage where you're just looking at the merits of the substantive petition after you already had instituted. As I mentioned before, majority of cases, the court will find the petition supported, meaning that the claims in question would be considered invalid under the standard that's being applied at the PTAB under the preponderance of the evidence. So I also looked at the technology class at the merit stage, and this is how the decision may vary versus that are supportive of the patentee versus against the patentee. And few trends, but one noticeable trend is that the biotechnology inventions, again, are somewhat different in that the biotechnology inventions are a little bit more, have a little bit more cases in which the panels will rule supportive of the patentee. Same thing with chemical inventions. By contrast, communications as well as semiconductors are somewhat against the patentee overall, certain trends. Looking at the patentee entity stage at the merit stage, there was a perception, at least some inventors feel that the PTAB disproportionately hurts small inventors or disproportionately rules against patent assertion entities. For the most part, of the ones that are against the patentee, the patent assertion entities would have a higher percentage against the patentee than they would be supportive of the patentee. And I also, like I said, wanted to compare district court outcomes to what happens at the PTAB. And this goes to the broader question of what should the PTAB be? And that may be a good question to ask at this stage. Is the PTAB, is it supposed to be a substitute for district court litigation, or is it supposed to be an adjunct to district court litigation? So I examined in my analysis how district court outcomes may vary when they're heard from the PTAB versus the district court. Now, a lot of cases end up being resolved at the PTAB initially, but when they go back to the district court, what ends up happening? And what ends up happening is that oftentimes the court, if the case is still active, they will still rule on subject matter issues, 101 validity. They will still later find the patent invalid for 112 written description or enablement issues or definiteness issues. In particular, when it goes back, if they end up filing the patent invalid, it's often due to 101 issues or definiteness issues. So, when the court finds it invalid, the PTAB often denies institution at a greater rate compared to it overall. So going into the 10-year anniversary now of the American Invents Act, I think the question remains, how should the PTAB be reformed? And how, I know other scholars are looking at how the PTAB has behaved empirically, and that would shed light onto maybe how we should reform the PTAB. And that speaks to the broader aim. Again, like I said, should the PTAB be a substitute for district court litigation, or should it be continuing as it is? And also, with respect to how do we see the PTAB within the broader administrative state? Professor Ray brought up some of the issues with respect to administrative law, issues with respect to the PTAB, and that's going to be an exciting area to see grow as the Supreme Court rules on some of the administrative law decisions regarding the PTAB. But some of the reforms that things to throw out there, should there be a standing requirement on the IPR petitions that would be similar to district court litigations? Should there be a stronger stay requirement at the district court that would make the stay mandatory, that would provide the PTAB being more of a substitute for district court litigation instead of more of an adjunct, and ensure more consistency among the district courts? Should you expand the challenges beyond prior art anticipation and obviousness to include other validity challenges? if you would truly see it as a substitute? Should you raise the standard of proof and how the panel should be constructed? For the most part, a lot of the decision makers, the panels are the same between the institution phase as well as the merits phase, but sometimes they're not. So sometimes the panels end up changing. Also, parties can also, like I mentioned, bring challenges in multiple petitions. So there'll be multiple decision makers that potentially could be deciding cases if they're filed at different times. Should there be some type of rule that requires parties to bring the petitions all in one petition rather than multiple petitions? So there's a lot of interesting things about the PTAB as we're going forward. And I think empirics will shed light into the broader issue of how the PTAB should be reformed as we get into 10 years of PTAB decision making.
Thank you, Professor Semet. So as the audience might be able to tell, we're moving from thinking about how why the PTAB was formed, and then we're evaluating data about what it's doing and who the people are, and we're going to now kind of maybe transition a little bit, continue thinking about what it's doing now, but also think about challenges to it and reform. And with that, let me turn it over to Professor Vishnubhakat.
Great, thank you, Professor Taylor. So like my esteemed co-panelists, I'm delighted to be here and really appreciate the opportunity to take part in this great symposium. I'd like to focus my remarks on an important theme that has emerged in PTAB review over the past decade. And it's a theme that promises to be quite important for reforms, as Professor Taylor mentioned, that might be considered going forward, especially reforms that have to do with the role of the PTAB as a substitute for federal court litigation, and also a source of greater efficiency in patent error correction. And that theme is agency discretion. Discretion is at the heart of a great many downstream issues that in PTAB review. And to make it concrete, I'll use the example of discretionary denials of petitions at the institution stage. This is an issue that's currently receiving quite a lot of attention in the USPTO and has been for about the last year and change. So the practice of discretionary denials is based on some pretty straightforward ideas. The PTAB, and more precisely, I mean the director acting through the PTAB, cannot institute a petition unless there is a sufficient likelihood, right? A sufficient likelihood of success on the merits. The power to decide whether that standard resides, at least in general, with the agencies. There are some exceptions, right? Shenanigans, as we've seen from the case law, but in general, the discretion, the power to decide that rests with the agency. And even if that necessary condition of likelihood of success on the merits has been met, the petition is not required to be instituted. The PTAB, exercising the director's discretion, can choose to decline review. And the current debate over discretionary denials and about agency discretion more generally really takes issue with this last point. The USPTO formalized its policy regarding the discretionary denial of petitions. After a series of cases over the last several years, it formalized its policy in a pair of PTAB decisions that the agency designated as precedential. And those were NHK Spring versus Intraplex, and so the NHK Fintiv doctrine, as it's called, specifically looks at how far along a parallel district court proceeding has gone and how quickly that is finished relative to the PTAB when deciding to grant the PTAB petition that's right in front of them. Okay. Now, near the tail end, the Trump administration, I'm sorry, can you hear me? I'm getting an internet unstable message, but I get that all. Okay, so near the tail end of the Trump administration, the USPTO considered utilizing this policy, which was laid out in these cases, these precedential opinions, through a rulemaking process. And since then, there's been quite a lot of pushback to these efforts, both the precedential cases and the rulemaking, which continues into the present day. And in particular, there's a case, an APA lawsuit that's been filed by a number of high-profile technology companies, Apple and Cisco, Google, and Intel. They filed suit under the APA against the USPTO to set aside the NHK Fintiv policy. And they make a lot of really careful and sort of well-considered arguments in opposition to the USPTO's policy. So in my view, I'm always on the lookout for a good teaching case. And I think this case, this dispute, is a really excellent lens through which to consider the legal and policy questions surrounding agency discretion as we look ahead to what the USPTO might do with the PTAB in the next decade. So 3 overall points with respect to this overall dispute. First, the Supreme Court case law regarding PTAB discretion has taken a very broad, permissive view on what the agency's discretion is. Full disclosure, I took part in briefing in at least one of those cases, Thrive versus Click to Call, and I've written in my academic commentary, along with Professor Rai and others, about the Quozo case and the SAS Institute case as well. So I wasn't necessarily on the side of the Supreme Court's eventual decision in every case, but the law is the law now, and so that's the sort of stance we begin with. Those 3 cases, Quozo versus Lee, decided in 2016, SAS versus Iancu, 2018, and most recently, Thrive versus Click to Call in 2020, give us some useful data points in sort of imagining how the Supreme Court views the discretion of the PTAB. In my view, Quozo is the strongest case for discretion. And by discretion, in this context, I mean the flip side of Professor Rai's earlier point about subconstitutional issues like judicial review, right? Because the question that was at issue in all of those cases was whether Section 314D of the IPR statute gives the discretion to act without judicial oversight, or whether there is in fact enough congressional intent evident in Section 314D as to each of those contexts that the presumption in favor of judicial reviewability has been rebutted. Okay, so I think when I say Quozo is the strongest, Quozo is the set of facts on which judicial reviewability was most defensibly taken away. The reason for that is Quozo had to do with simply the, as Justice Breyer's majority opinion said, the mine run claim of seeking review. And the question of whether the petition was pled with particularity is an evidentiary question. It has to do with the merits, yes, but it's closely bound up with the likelihood of merit standard and is sort of closely tied to that question, and as a result should be immune from review. Quozo was the strongest. In my view, SAS was probably the worst, because although we sort of think SAS versus Iancu as upsetting the act of partial institution, which is a practice that the agency had undertaken for a long time, the actual argument that occasioned that appeal was whether the final written decision agency issues that the PTAB issues address all of the claims that were challenged or only some of the claims. The PTAB said, well, clearly, since we only instituted upon some of the claims, we only have to issue a final written decision as to some of those claims, the ones we instituted on. And it was necessary to sort of fight about partial institution in the first instance, because the eventual question was whether the agency's obligation of final written decision and reasoned decision-making in that regard was within the agency's discretionary power to shape and reshape as it saw fit. And I think taking account of that, this idea that yes, agency discretion is broad, but if it extends all the way through to decisions that are themselves reviewable, then that might be a bridge too far. And I think it's a fair reading of SAS to say that one of the reasons the court was concerned about whether the statute was really appropriately read as allowing partial institution or not was that it implicated other much more important values of reasoned decision-making that the agency eventually did have to satisfy. So Quozo went one way, there's no judicial review. SAS went the other way, there is judicial review. If you count the votes and sort of see how the composition of the court had changed, there's some interesting trends, and if there are questions about that, I'm prepared to address those in the Q&A. But Thrive is the interesting case. It's in the middle. At the time I wrote a paper in 2018 about what I call the porous court agency boundary in patent law, the leading case on that was actually Wi-Fi 1 versus Broadcom, which was an en banc decision of the Federal Circuit that said the 1 year time they bring your petition to the PTAB within 1 year of being sued in district court is, after all, judicially reviewable. The panel decision had said it was not. En banc, the Federal Circuit reversed, said it is reviewable. That was exactly the same question that came up in Thrive versus Click to Call, and under Wi-Fi, the Federal Circuit said, yes, it is reviewable. But the Supreme Court went back and said, no, it is not judicially reviewable. And because the facts of Thrive, the facts of Wi-Fi 1, are sort of between quoso, it's not quite as easy a case as quoso to take away judicial review. It's not quite as easy a case as SAS to grant judicial review. It's a good middle point to sort of figure out, differentiate where the justices might sit on this question of agency discretion. And in that case, the court said that there is no judicial review. So on balance, it's sort of a 2-to-1 split in favor of agency discretion if you simply look at the cases that the Supreme Court has issued. Now, there's also some dispute, taking this Supreme Court case law as a starting point, there's some dispute in the discretionary denials context about how the agency can articulate the exercise of its discretion, whatever that discretion may be. One view is that it must be through rulemaking. At the time that NHK Fintiv was being sort of debated and this lawsuit was filed, this APA suit was filed, it was primarily a set of precedential decisions. There had not been rulemaking. Since then, the agency has undertaken rulemaking, and that's sort of in abeyance because it was at the tail end of the Trump administration. And although we are now in the Biden-Harris administration, the new USPTO director, of course, has not been appointed. And in that interim position, we're sort of in holding pattern. So can it be done merely through adjudication, or must it be done through rulemaking? My view, and this in some writing in the popular media like Patentability, I think adjudication is perfectly acceptable. The Supreme Court, going back to its 1940s decisions in SEC versus Chenery, and in quite a lot of case law since then, has said the form of agency decision-making between adjudication and rulemaking is really up to the agency. And it's perfectly acceptable to do that. Now, as a matter of administrative practice, good administrative practice, I think prospective is far preferable, but a well-advised preference, I think, is not the same as a legal requirement. And of course, now the agency is gathering information and considering a rule. So that's not as much an issue going forward. However, what we do need to care about quite a bit going forward is the unstated, initially unstated, but now increasingly interrogated question, empirical question of whether the agency's desire to look at what's going on in the courts is well-founded. That's an empirical question because the agency assumes that when a trial date is set, when we've seen a case go in the parallel proceeding go sufficiently far, that it's probably going to finish before the PTAB would reach its one-year deadline. And the PTAB has been quite good about reaching its one-year deadline. So, we, the PTAB, goes the theory, should not invest our resources in a situation where the district court's going to reach the decision first anyway, and the district court is probably likely to stick to its trial schedule. It's not going to vary very much. And so is the trial date empirically a reliable measure of how fast the decision will be reached? And then the overall cost benefit analysis of whether agency resources short of might still be better spent elsewhere. Those are all empirical questions that need to be vetted in order to figure out not whether NHK Fintiv is possible or permissible, whether it's advisable and a good plan for PTAB administration. And that's a current project of mine that's nearing completion. So please be on the lookout for that. In all, I think the question of agency discretion, and I'll close with this, is a little bit ironic, right? Because a lot of the pushback that's coming against the agency and saying you don't have the discretion to do this is being mounted by at least some of the same people who were quite enthusiastic in the early days of PTAB discretion, filing amicus briefs in quoso and SAS and so forth, saying, of course, the agency has very broad discretion to do, at least what we like that it's doing. And now that the tables have turned, it's perfectly understandable that we might say, okay, well, let's put the brakes a little bit and see if we're not going too far. Because the PTAB was intended, at least in the minds of many, as a way of weeding out poor quality patents. And as long as it's doing that, discretion is fine. As long as, once it starts to turn around and, protect patents that may not deserve protection, we should take a closer look. And I don't think it's necessarily inconsistent to do that. But of course, the language of the court cases discretion has been quite broad. and we have to deal with that. Because Quozo, SAS, and Thrive were all about discretion to grant a petition when the statute might not be appropriate to grant review, okay? And discretion to grant is not identical to discretion to deny. That's true. So there is a principal distinction there. But which way does that difference actually cut? Because the fight in all those cases was, is the agency overreaching? That could pose separation of powers problems and actions that are ultra vires. So, okay, now that we know that even in that very controversial setting, there's a lot of discretion, now the question is whether the agency is underreaching. It's choosing to decline power that might otherwise have. And I think underreaching simply doesn't pose the same separation of powers problems. So the broad language that we've seen in the even more contentious cases more than covers the current position of the U.S. in choosing to decline review. But all of that is subject to the caveat that the empirical data may say otherwise. And that'll be a question that remains to be answered. Thank you.
All right, thanks to all of you. Now I'm going to use moderator's privilege since we went a little long there, which is fine because you guys had interesting things to say, but we only have about 10 minutes left. So let me do this. Let me just direct 1 or 2 questions to each of you, and I won't get everybody to respond because it would probably take too long, and I want to hear from each of you on the questions that I have. So Professor Ryan, let me start with you. I'll mention a previous question, but then I'll ask the second question, which is I want you to, they kind of relate to one another. So my first question was, has the power in the US patent system's institutional structure shifted to any significant degree from the federal courts to the USPTO and particularly the PTAB? But in how I want you to address this actually is from an administrative law perspective. And so the follow-up is, are the USPTO and the Federal Circuit getting the relevant administrative law correct?
So great. Well, so part of the challenge is that I think administrative law is shifting under our feet to some extent, and that's one thing that I didn't bring out in the affirmative remarks I made, but I think is important to point out that when some of us began laboring in these fields, it felt like administrative law was, at least relative to other areas of public law, not necessarily an area where there would be vehement contestation, whereas now it's pretty clear it is an area of vehement contestation. So I think that, you know, in general, it's harder as a consequence because of that vehement contestation. But let me not duck the question, because I know that they might be perceived as ducking the question. Just say that, well, it's hard to say because administrative law is so ambiguous right now. So in terms of where I think administrative law is right now, I think overall the Federal Circuit is mostly getting it right. I mean, there are some nuances that I think the Federal Circuit is missing, but I think it's recognized that that the PTAB has substantial fact-finding authority, for example. I think it's gotten some things right about challenges, and again, I'll go back to Arthrex with respect to, this is administrative and constitutional law, challenges to the way the AIA structures PTO director review of the PTAB. I do think that there is a challenge there, and it would be much better if the AIA had been written a little more cleanly in that regard. So I think, yeah, I think that with respect to at least the current Supreme Court, it seems to be reading the tea leaves pretty well.
Great, thanks. So Professor Semet, let me turn to you. The PTAB was notoriously called a death squad at its in its early days. And one thing, as you think about the empirical data, I'm curious if you studied or you have seen any, if you studied any shifts over time, and if there were any shifts over time, for example, in the full invalidity rate. Does that show up in the data? Was it a death squad at one point, and maybe is it not now?
I think you need to look at particularly how they may vary depending on the technology type and the patentee type, for instance. So like I showed in my presentation, the PTAB disproportionately probably invalidates patents where the patentee is one of the patent assertion entities as compared to a corporation. So I think over time, it's been fairly consistent over time, but with respect to the rates with respect to the validity. But that can really vary by the technology type. So I haven't really looked at it broken down, for instance, by Because I think general trends really don't tell you as much as it broken down, for instance, by if there's a companion district court litigation or not, if there is who are the parties involved in the case? Is it a complex case? Is this case one of multiple PTAB petitions? So in my future research, I think that I'm going to analyze a lot of those issues as well to see the trends over time when you see things more fine-grained broken down by that, as well as what may be changes with respect to how they may be instituting petitions as well as ruling on the merits of the PTAB petitions.
Great. And let me ask you one follow-up, because this is going to tie into what I in my next question. So I noticed that you have studied political control over immigration adjudication. And it's interesting to me because the way I have a lens through which I view Arthrex, which is going to be argued at the Supreme Court on Monday, and it's about the PTAB and its judges, so it's very relevant. But in my view, the Appointments Clause is about political control over officials in the government. And so I'm very curious, based on your study of political control over immigration adjudication, what insights does that provide with respect to the PTAB, if any?
Yes, in my respect to immigration decision making, I've analyzed along with Catherine Kim all the immigration court decisions going back to the Bush administration to see whether the appointment of who appointed the immigration judge, as well as whether there were changes between Trump era and Obama era. And what we found was that it didn't matter who appointed them, but it mattered what the era was. So for instance, all judges, regardless of who appointed them, were just more likely to remove non-citizens during the Trump era as compared to the Obama era. Now, I think a similar lens can be applied to analyze the PTAB to see the impact that political ideology has an impact in decision making. One of the reasons why I'm collecting all this information regarding the demographics of the PTAB judges is to analyze trends with respect to, for instance, does the panel's scientific expertise impact decision making? Are there panel effects with respect to the judges? There's a robust literature in the Court of Appeals literature with respect to the impact that 3-judge panels with respect to racial and partisan and gender diversity may have on decision making. So you can apply that literature to analyze the PTAB decision making, to analyze trends in panel effects with respect to both institution and substantive decision making at the PTAB.
Excellent. So we'll be looking forward to reading your analysis. So, but actually that does tie into my question to Professor Vishnubhakat, because you focused on discretion and I think giving the Patent Office discretion, which actually ties into Professor Rai's previous work, I think giving the Patent Office power, right, as a manager in the patent system. But when you talk about discretion and then you talk about politics, I'm curious, I told my students even this week, patent politics are not Republican, Democrat. They're different politics. There's politics. They're different though. But I just want to challenge you, or at least get your response. When you think about discretion at the Patent Office, should politics play into that? How do they play into that? And with particular focus on maybe Arthrex and the Appointments Clause.
Yeah, that's a great question. It's there are two ways to understand this. One is the distinction between adjudication, not as far as what the agency can choose to do, but what power the agency should be. I think it's fair to say, although PTAB review, IPRs, and so on may not be considered in the Section 554 sense of the word, of the phrase, as many have said, sort of persuasively argued, it's sufficiently formal in the sort of type 2 adjudication that it warrants Chevron deference. And Professor Rise argued that if the agency doesn't get it, it's because they're not asked, and that it's not because they couldn't get it if they asked. So there's that side of it. Now, substantive rulemaking authority could be a way for the agency to speak with the force of law in a very politically sensitive and responsive way, but that has been a choice that, for a variety of political reasons, Congress has not chosen to give power to the agency. So that's one sort of political dimension to it. How much do we trust an expert but nevertheless politically inflected agency to make its decisions? And the answer is a little but not a lot in the case of the Patent Office. Maybe not enough to give it substantive rulemaking authority, but enough to take advantage of its technocratic capacity. The second, and this really goes to your point about Arthrex and the appointments power, is that we focus primarily on the Patent Office in the context of these powers. We focus on it primarily as a source of expertise when we talk about decision making. But of course, the AIA, when post-grant review creates additional grounds, to institute PGRs or CBMs when they existed, not just because the petition might have a likely success on the merits, but also separately, it presents a new and important question of unsettled law, right? It's explicitly saying, agency, you have the power through adjudication to make new policy. And the federal circuit will be there as a backstop and so on. But take that view without taking similar account for all of the different political expansions the agency has undergone. In 1999, it used to be that the head of the agency was the Commissioner of Patents. Then it became the Commissioner of Patents and Trademarks. Then became the Assistant Secretary of Commerce. Now the Undersecretary of Commerce and the principal advisor to the President on all matters relating to intellectual property. Similarly, the things that they have done went from ex parte appeals over things and post-grant sort of revocations following the 1980s, and now a much larger set of tasks that include subdelegated powers from the director with the political power, the political authority to determine whether institution is warranted. It used to be that examiners in chief, which were the precursors of APJs, were always appointed by the president, nominated by the president, with the advice and consent of the Senate. That was changed in 1975 to Secretary of Commerce appointing them. And then it was changed again in 1999 to the director appointing them, which of course, because they're not employees, they're at least inferior officers, was corrected by Congress when Professor Duffy published his famous article. So now we're back on the upswing to say the power of APJs has been growing and growing, and Congress meanwhile has been changing their appointments mechanisms downward from principal to inferior to mere employees. That can't possibly be right. If they're going to exercise so much power, and a fair amount of that power is politically inflected, then the appointments mechanism should keep pace. And depending on how Arthrex turns out, it could, of course, have implications across the administrative state. But I think it's fair to say that the longer historical arc suggests that APJs should be treated with greater respect in the appointments process, not less.
Thanks. I see we're out of time. We're over by 1 minute, but I do have to ask. I mean, Arthrex is on Monday. I'm just curious. I'm guessing none of you will say, but does anybody have a prediction? Does anybody want to make a prediction?
I might make a prediction if this weren't being recorded. But
Okay, well, it was worth a shot.
Yeah.
I'll say that it'll be a lot of fun to watch the argument.
For sure.
That's a prediction everyone will agree with.
That's right.
Yeah, there you go. Well, with that, I wish we had an hour and a half. We had 1 hour, but I want to be respectful of everybody's time. This is what we committed to. So let me just thank you, the panelists, for your insights. And now, on behalf of both myself and my co-director, Keith Robinson, I want to take this opportunity to thank Natalie Greco for her assistance with so many administrative issues and making this work. It went off very well today. Thanks to all of our speakers today and you, the audience, for attending. We hope that these presentations have opened your mind to understand how the American Invents Act came to be, how it's impacted patent law and patent practice, and how its changes will continue to be a central focus of practitioners, judges, and researchers going forward, including on Monday. So again, if you're an attorney, you'd like CLE credit in Texas, you can email thaicenter@smu.edu, provide your name and Texas bar number. And if you'd like more information on the Tsai Center and its events, please connect with us on Twitter at SMU Tsai Center and on our website at smu.edu/law/centers. With that, look forward to connecting with all of you in the future. Thank you.